14th District Court for County of Washington, State of Michigan is now in session.
You may be seated. And where is everybody?
On Zoom, Mr. Freeman and Mr. Smith.
Okay, yep, got you. Some people are supposed to be here live and they're not. Hang on, are we ready on your case? Because you need Miss Reiser.
Yeah,
And
I'm hoping that she's going to be there very quickly because last time we ended up waiting a couple hours.
Well, like everybody else, there's one of me and a bunch of you.
I understand, Your Honor.
It's like, thanks for pointing that out, Mr. Freeman.
I have a tendency for the obvious, Your Honor. I'm very skilled at that.
All right, we got more on that side. About time you show up, Feaster.
I'm always running behind you. I apologize.
No, you were all the way out there. Everybody said you were fooling around. Are you ready? Mr. Freeman, we're looking for Miss Reiser. As soon as she arrives, we'll try to. Yeah, she's next door. Doing what?
I know
she's next door.
Just walked in.
Sitting there.
Stood in before.
She was talking. Okay, go interrupt that. As long as it's not to a judge, and let's get her in here. Mr. Feaster, you ready on anything?
I don't have my client here yet. I need for this case, Judge.
So when you looked at your watch, you thought your client was going to show up? Okay.
Good morning, Judge.
Good morning.
Did you call the case?
I haven't called it. Or it does call the case of people, state of Michigan versus Raymond Smith.
Good morning, Your Honor. Amy Reiser on behalf of the people.
Good morning, Your Honor. Attorney John Freeman appearing via Zoom with my client Raymond Smith, who is also on Zoom.
Mr. Smith, can you state your name, please, sir?
Yes, Your Honor. My name is Raymond Smith.
All right. And what are we doing on this today? I think there was an issue with medical.
Your Honor, I'm beyond frustrated. 6 months ago, we filed a motion for the disclosure of the medical records. And every time this has come up, there's another reason why we don't have them. I'm asking the prosecutor to give us a firm commitment on when we're going to get them. And if we don't have them by whatever date she picks, I'm going to be asking the court to preclude the witness from testifying, because it's my belief that the medical records will contain exculpatory information. It's inconceivable to me, with all the motion practice that we've had on other issues, the courts resolved those issues, that we're still waiting on medical records. I just don't get it.
Mr. Reiser.
Thank you, Your Honor. Discovery has been provided in this case, and that includes a sexual assault nurse examination and a kit that was done. So everything has been provided. Counsel requested the additional ER records that may have been generated when the victim went to the ER and received the sexual assault nurse examination kit. There is a law called HIPAA. We can't just obtain anyone's medical records without their consent. Deputy Campanori obtained a consent at one of our last hearings, tendered it to St. Joe. It was the wrong form. He has since gone on medical leave, so I don't know if he got the correct form signed by the victim to get just those ER records before she got the same kit. And that's what I've been trying to determine over the last few weeks, but he is out on paternity leave, so I have not been able to obtain those. But we are trying to obtain those. And when I have them, I will turn them over if I'm able to obtain those. If not, then Mr. Freeman is free to file a motion. I don't know any law or anything that would allow the victim to preclude her from testifying.
She won't be able to testify as to medical. If it's not provided, I can certainly order that. So, that will be the law. I mean, there is case law that permits the court to do that. That's what Mr. Freeman is asking.
Well,
I don't want to do that. It's an extreme remedy, but I think we've been waiting for these medical records. Isn't there another officer that secure the consent form. Well, I guess I have two questions. First of all, do we know when the detective is coming off of maternity?
I was trying to find that out. I believe it's July 20th that he'll return to work. But the internet is down. I'm not able to connect to the network for some reason this morning or yesterday. So I believe he is back the 20th. So if we set it on the 30th, I should have an answer and possibly there is another officer.
Right. My concern would be that even if the proper form hasn't been secured, he comes back on the 20th, and let's say by way of circumstance, he gets it that day to St. Joe's, they're not going to have the medical records in 10 days. I mean, that's been my experience with dealing with the release of the medical records. They don't get them out that quick. Have did you file a new motion to compel? Mr.
No, Your Honor, we filed one 6 months ago. It was.
No, I know. I
something that
asked,
was
listen to my
stipulated
question. Did you
Sorry.
file a new motion to compel the discovery?
No.
I know what's been ordered.
And there was just, the people agreed to obtain these records, and it sounds like they attempted to
I know.
obtain them once.
Dear God, I know all of that. I asked a question. And I'm presuming the answer is no. So here's what I'm going to do, so that we don't have to keep coming back. My next day is the 30th. I'll adjourn the preliminary examination to the July 30th. That's my next date. Looks like we 9 a.m. I want an update written to the court, sent to my office on the status of the medical records. I want that by Friday the 26th.
May I speak regarding scheduling?
Excuse me?
May I address the court regarding scheduling?
Go ahead.
Your Honor, the 30th, I don't believe I'm going to have enough time, even if they get me the medical records, because I am going to be out the last half of July. So I'd ask for whatever the court's date following July 30th would be for the preliminary examination. And I'd ask that the 30th be set as a control date so that we can make sure.
Well, I'm not setting two dates. I'm here on the 13th. Is that right?
Yeah, it's 12.
Pardon?
There are 12.
On that date?
Yes.
Thank you. August 12th or 13th, excuse me, August 13th, 2024, 12 noon. It's a new time for a preliminary examination. Still want the update on the medical by the 26th. Bond will continue. Thank you.
Thank you.
Thank you.
Who's next? Where'd they all go? They're Ellen, they're like squirrels. What the heck is Constantino doing here? You know what?
Kick her out.
Took my words. Is Goldstein ready?
Yes, Your Honor.
You're ready on yours?
Not here yet.
We have him.
Mr. Goldstein.
Oh, he's in custody.
Oh, yeah, we have him. We did that for you.
Oh. Sometimes.
Did you want to talk to him before he comes out, or?
Oh, seriously, he's in custody?
Yeah.
Yes.
Okay, no.
Oh, you thought I was joking?
No, I thought you were joking.
No.
No, we're ready.
When they're in custody, I'm serious. You ready?
Ms. Johnson. Yes.
What?
It's not up to you.
So, I thought we.
You see, we looked immediately.
Okay, I'll ask her to send them again, but it's not up today, right?
No. I want to anticipate.
Okay.
Because I want to be able to set it for exam on Thursday and you won't do it unless it's got done.
Ms. Cannon, are you ready on yours?
No.
Okay. Yeah, okay. Court does call the case of the people versus Avion Johnson.
Nicole Hughes on behalf of the people.
David I. Goldstein appearing on behalf of the defendant.
Okay, date and time for preliminary examination. We ready?
Yes, Your Honor. Present in the courtroom, I have Officer Escobar, who I'm going to ask to remain in the courtroom as the officer in charge. I also have Officer Lake, who I'm going to ask to step out in the hall. I don't have anybody else present in the courtroom, but if anybody else. And if they may call me first witness.
Yes, you may.
People start by calling Officer Escobar.
Sir, please come forward to be sworn.
Will you take a seat, raise your right hand, you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Will have a seat. State, spell your first and last name for the record.
First name Francisco Akbar, A.M. Last name Escobar, E.S.C.O.P.R.
May inquire.
Officer, where are you currently employed? In what capacity?
As a police officer.
For how long have you been employed as such? Were you working in your capacity as a Pittsfield police officer on June 12th, 2024?
Right.
On June 12th, 2024, were you working around 23:17 hours? On that date and time, were you working in the area of Washtenaw Avenue and Forest Ave in Pittsfield Township, Washtenaw County, Michigan?
Washington, Foster, yes.
Sorry, thank you. Washtenaw and Foster Avenue.
I was gonna say.
What did I say?
Go ahead.
I'm sorry, guys. Thank you. How did you come to be involved in this investigation?
I saw a vehicle with multiple different equipment, which was a front headlight, and a license plate that were and issue a traffic stop on the vehicle for the.
Your Honor, this witness has a very soft voice. I'm having a little trouble hearing, so if you could speak a little bit louder.
I can, yeah.
It has nothing to do with your voice. It's his hearing, but go ahead. Please speak up. You're good.
I'll admit it.
All right. Okay.
Did you have the opportunity to effectuate a traffic stop on the vehicle?
Yes, I did.
Did you have the opportunity to make contact with the vehicle?
Yes, I did.
Which side of the vehicle did you first approach?
I told the driver's side.
Did you make contact with the driver?
Yes, I did.
Who was the driver?
He was identified as Adrian Johnson.
If you were to see Avion Johnson again, would you recognize him?
So I would.
Is he present in the courtroom today? And could you please identify him for the record? Thank you. Is he sitting or standing? Thank you. Your Honor, please let the record reflect that the witness has identified the defendant.
Without objection, record show so reflect.
Did you have the opportunity to determine whether there were any other occupants in the vehicle?
A front seat passenger.
And do you know who the front seat passenger was?
We did.
Did you provide that name? Thank you. After you made contact at the driver's seat, could you please tell us about your initial interaction with Avion Johnson?
Noted that he was aware of the defective equipment. I proceeded to ask for his driver's license, which he provided me a state ID. I then asked his registration and insurance, which he said was on his phone because it was his girlfriend's car. But then later proceeded to open the glove box and where the pistol glove box.
When he opened the glove box, were you able to see the pistol? What type of pistol was it, if you know? Do you know whether there was any ammunition in the firearm? Was there a point that that firearm was collected?
It was collected, yes.
Who collected that firearm?
I can't remember his name. I know that he worked in Washington County.
A deputy?
Yeah, deputy, yes.
Did you have the opportunity to observe the firearm after it was collected?
Yes.
After, from your observations of the firearm while it was in the glove box and after it was collected, are you able to tell us whether or not it was a real firearm?
Yes, as soon as it was collected, it was handed over to me, and I could tell that it was, yes, it was a real firearm.
Okay, thank you. I want to go to the statement where he said that it was his girlfriend's car. Were you able to determine who this vehicle was registered to?
We were,
Fair to say it wasn't registered to Avion Johnson.
it was not.
Thank you. Do you know whether any other firearms or ammunition were collected from the vehicle?
There was a second firearm located in the vehicle behind, I believe, the driver's seat.
Where behind the driver's seat?
I'm not very sure because I didn't get a chance to see where the gun was recovered from. I just know that it was taken from that area.
Do you know who recovered that gun? Thank you. Did you have the opportunity to see that firearm after it was collected?
Yes.
Do you know what type of firearm that was? If I were to ask you if it was a handgun or a rifle, would you be able to distinguish on that? What type of gun was it?
I believe it was a handgun. There.
A handgun. Okay. Do you know from your observations after it was collected whether or not this was a real firearm?
Yeah.
Thank you. Did you have the opportunity to inquire as to whether or not Avion Johnson had a CPL?
I did. As soon as I saw the handgun, I asked him to relax and immediately asked him to get his CPL, and he said no.
Your Honor, may I have one moment?
Yes, you may.
Thank you. Questions for this?
Thank you. Cross-examination.
Officer Escobar, when you were on duty that night, did you have a partner or were you driving by yourself?
I was by myself.
When you observed the vehicle and decided to stop it for a traffic violation, you turned on your overhead lights, gave some kind of a signal that you wanted the vehicle to stop. Did the vehicle stop?
The vehicle stopped, yep, after pulling up a Dodge parking lot, yes.
Okay, so there was no issue of him trying to avoid you or evade you, or you had to chase him down or anything? He just basically pulled into the lot and you, okay? As you were approaching the vehicle, could you see inside the vehicle? Okay, did you see the driver of the vehicle reaching toward the glove box?
I could not see anything.
Okay, so the answer is no, you did not see that. Okay. So you approached the vehicle and you asked the driver, Mr. Johnson, for his driver's license registration, the usual paperwork, correct? Okay. And he produced a Michigan ID card. Is that correct? Okay. And then you also asked him for registration and insurance.
Yes.
And initially he told you they were on his phone.
Yes.
And he started to do something to show it to you. Is that a fair statement? Okay. But then at some time he said to you, or said to the driver, I'm sorry, the passenger, Mr. Harper, is it?
Yes.
Okay. He asked him to go into the glove box and give him the registration. Is that correct? So Mr. Johnson had no problem saying to somebody else, with you standing by the car, go into the glove box. Right? Okay. Now you said you were driving alone, but you did have other officers present or deputies present at some point. Is that correct?
That was after I saw the back glove.
Okay, so okay, fine. So Mr. Johnson is sitting in the driver's seat. Mr. Harper is sitting in the passenger seat. Who was closer to the glove box, Harper or Johnson? Okay. And Johnson had no problem saying to him, go in the glove box and get the registration or insurance, whatever, correct? What was Mr. Harper's response when Mr. Johnson asked him to do that?
Not move at all.
Okay, so Johnson has no problem asking him to go into the glove box. Harper doesn't want to open the glove box. Fair statement? Okay. When you asked Mr. Johnson later about the gun, whose gun it was, what was his response? So he never said to you, yeah, that's my gun, I put it there. Fair statement? Okay, nothing further, Your Honor. And I take it you don't know much about the other weapon except that it was recovered by somebody else. Okay.
Did Mr. Johnson say anything to you about how Harper came to be in his vehicle?
Yes, I believe he said that he was in the area.
So Johnson was in the vehicle, picked up Harper from somewhere, and then at some point you pull him over after Harper gets in the vehicle. Thank you.
Nothing else?
Yeah, thank you, Your Honor.
Officer, thank you very much. Step down. Call your next witness.
I would love to call Deputy Phillips. However, I understand that he is still on his way.
Let's approach, Your Honor. We may be able to short circuit.
Thank you.
So I guess, yes, you may approach.
Sorry.
Come on. No, Goldstein, it's not you. It's Goldstein does this all the time.
Don't be shy, speak up next.
No, you're not. Just listen. All right. So what are we doing?
Your Honor, this time people have no further witnesses.
We have no witnesses.
All right, very good.
And Your Honor, I have a motion to bind over on the information as written.
Well, Your Honor, I'm not going to address, I'm not sure which gun is which, but we can figure that out later.
Count one is the glove box.
Count one, okay. Your Honor, I'm not going to object to the bind over on count two. I think ultimately it's a jury question. We're not conceding that it was my client's weapon or he knew that it was there. We're simply saying that's up to the jury to decide. But with regard to count one, not only had the people not produced any evidence that my client knew that the gun was in the glove box, they produced evidence that he didn't know it was in the glove box. You got a situation where the officer approaches, he couldn't see anybody's hands. I know that goes to my client also, but it also goes to Mr. Harper, who's sitting in the passenger seat, who's right there in front of the glove box. When Mr. Johnson is asked for the driver's license and registration and insurance, when he tries to pull it up on his phone, he then says to the passenger, go in the glove box and get the information. Is Mr. Johnson going to ask him to open the glove box knowing that there's a gun in the glove box? And what was Mr. Harper's response to that? Which was, no, he didn't want to open the glove box. So not only have they not shown any evidence that my client knew that it was there, but I think they've shown evidence that he probably didn't know it was there. And therefore, I don't think even on a probable cause basis, they've established enough to bind over on count one.
Response.
Those exact same facts can be used to establish why Mr. Johnson knew that the firearm was in the glove box. The officer directed Mr. Johnson to produce the registration and the insurance. He didn't ask Mr. Harper to produce it. So Mr. Johnson took the opportunity to tell his passenger to lean over to the glove box, which he knew had a firearm in it, rather than Mr. Johnson himself leaning over to the glove box to produce the license and the registration himself. Also, we've elicited testimony that Mr. Harper wasn't initially in the vehicle, that Mr. Johnson went and picked him up. So to the extent that there's any type of factual argument about Mr. Harper being the possessor of the gun, he would have been in the vehicle when Mr. Johnson picked him up, which would lead to an argument on our part that perhaps if Mr. Harper put the firearm in the glove box, it's while Mr. Johnson is driving the vehicle. Also, count two, the fact that he does have a firearm that is being bound over within his arm's reach, and he's purposely not reaching over to open the glove box, is our factual argument that he knows that there's a Glock in the glove box as well. Thank you, Your Honor.
Thank you. The court, after hearing the testimony, is going to decline to bind a defendant over on count one. I think Officer Escobar's testimony clearly indicates that this defendant asked the glove box to be opened. It's unlikely, and the court would believe that he wouldn't have said that had he known there was a firearm there. He said nothing about the one that was located in the proximity of the driver. It also wouldn't make sense necessarily that he would have two. That one is right in front of Mr. Harper. Mr. Harper's the one that then hesitates to open the glove box. I don't think that the people have sustained their burden of showing, even by probable cause, that this defendant possessed weapon as the glove box device or weapon. So the court's going to decline to bind over on count two. Defendant is bound over to stand trial on count one. Defendant is bound over to stand trial on count two.
Your Honor, for purposes of arraignment, we would waive presentation of an amended information. My client would waive reading and would stand mute.
Defendant every way, former reading, standing mute. Court will enter a not guilty plea as to that charge. Pre-trial in this matter will be set for
August 20th at 1:30 before Judge Cumbie.
August 20th, 2024, 1:30.
Thank you, Your Honor.
Thank you.
Thank you.
And thank you, Ms. Houston. Did you want to, are you going to prepare a new one or are you going to cross this one out?
I'll cross it out.
Okay.
Thank you. Thank you very much. I'll have them send it to you again.
Okay.
Oh,
Well, Melody's going to call Sarah, so she'll take care of
All right.
okay. What's today? The 9th?
it. Ninth.
Thank you.
Tell her to sit down.
Sorry, I started writing on it as if it was mine. Sorry about that.
Did you take her pen?
It's an attempt.
Don't talk to Odetella either. You ready? Court does call the case of the people versus DeAndre Brandon.
Good morning, Your Honor. Laura Bowman on behalf of the people.
Stephanie Cannon with the Public Defender's Office with and on behalf of Mr. Brandon, who is standing to my right. Mr. Brandon, could you please state your name for the record?
DeAndre Brandon. All right, what are we doing?
Your Honor, at this time, we would ask for dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice on defendant's.
Thank you, Your Honor.
He's shaking her hand. She didn't do anything. She didn't do anything. She was just present. Court does call the case, people versus Jeffrey Shear. Oh, I didn't know this. Why did you call it Constantino's case?
Good morning, Your Honor. It's great to see you. Christina Constantino appearing with and on behalf of Mr. Shu. Mr. Shu, can you state your name for the record?
Mr. Jeffrey Shu. All right.
Your Honor, at this time, the people are not able to proceed.
Your Honor, we would be moving for dismissal of this matter.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice.
Thank you very much, Judge.
Thank you.
Have a good rest of your day. See?
your service.
Hey,
Thank you, sir. Oh, no.
Mr. Brown.
Why does she need an adjournment?
I didn't really talk to him. I'm not allowed to talk to him, so I don't.
Hold it. Let me see. And why are we up here doing that? I don't know. Never mind. I'm just calling. Wait, give me an answer. Court calls the case, people state of Michigan versus Jacob Watkins.
We're ready in that matter, Your Honor. Your Honor, has a waiver, I'm sorry, has a waiver already been put on?
What?
Has a waiver already been put on?
No.
Well,
So I need a waiver.
it's a good thing I'm here. Lauren Brown, Deputy Chief Public Defender. Your Honor, we do not believe that any conflict exists in this court hearing this matter or the matter before it involving Ms. Stephanie Cannon. If a conflict were to arise, we would waive that conflict so this honorable court could hear these matters.
All right. And from the people, is there a waiver of the? You don't know.
Yes. Laura Bowman on behalf of the people. I missed that. Is your client waiving? Okay. Oh, yes, of course. Sorry. They didn't teach you that yet.
I could do it for them.
Seriously? No, it's okay.
Would waive any conflict between this honorable court and the public defender's office, so that people do not believe that such conflict exists, that people make this waiver in avoidance of any doubt.
Thank you. And the court for its part also does not believe there's a conflict either in the Michigan court rules. Other cases decided they're under to the extent a conflict exists, given the waivers, the court will consent to hear the matters.
All right, thank you, Your Honor.
Thank you.
So, Your Honor, in today's matter, Mr. Watkins has made it into the mental health court. He now has an interview with the CARES team so they can set up a program for him. So we're asking for I think it's been 3 weeks. What's
The appointment's on the 18th at 10 a.m.
You have an appointment on 18th.
So we want to set it past.
So if I set it on the 30th, you think
I should know something by then.
okay.
Okay.
No objection from the people. All right. Preliminary examination in this matter will be adjourned to July 30th, 2024. 9 a.m. Bond continued.
Thank you, Your Honor. Thank you. All set. All right, look.
Ooh. When do you want? Why? Oh, for Pete's sake. Seriously. Oh, they're witness.
Yeah.
She let the PD know.
Witness and the PD to go back together. So they.
Oh, so they both went together. Got it.
But we just lost Mr. Feaster. So I don't have anything to give you right
So is there one that's low that they can launch?
Yeah.
All right, Judge.
No. I don't mind waiting for you.
I apologize. I don't want to make the court wait.
Are you ready?
I'm ready. Ready.
Court does call the case of the people versus Emil Thomas.
Sophia Perry appearing on behalf of the people.
Ready, Judge. Torshio Feaster, Assistant Public Defender, appearing on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Emil Thomas.
Thank you, Judge. I've spoken to Ms. Curry and to Mr. Thomas. We do have an offer on the file to resolve it. However, I'm gonna ask for a brief adjournment. I'm gonna put together a little bit of a mitigation report and proof of his current CPL license. And then hopefully be able to come back in a couple of weeks if the court will allow and get it all resolved. I think Mr. Thomas is hoping to sweeten the deal a little bit. And I think he wants to try to adjourn it for that purpose, Judge.
I have no objection to that, Your Honor. The current offer from the people will be to plead to an added count of improper transport. That is MCL 750.227D, a 90-day misdemeanor and for a $100 fine. The original count one carrying.
And that's a great offer, Judge. We're very appreciative.
Oh, yes, it is.
It is. And I relate that to my client. He's just asking for just a short adjournment so he can look into that a little further.
And if I said no,
Then he would take it to that judge. To be honest with you.
that's what I thought. But you want to send some mitigation information.
I do, Judge. I apologize.
Preliminary examination in this matter will be adjourned. I'll give you an opportunity, July 30th, 2024, 9 a.m. before me.
Thank you very much, Judge.
You're welcome.
All right.
Bond.
My number.
You know, that was. That's all I have? Why is?
I can do my exam without a judge. Right. I'll go find her.
Well, no, we know where she is. She's dealing with. So I can't do anything. All right, I'm out. I mean, of course, it's recess.
All rise.
You want to call Wheaton first? It's going to be a waiver.
All rise. The 14th District Court of County of Washington, State of Michigan is now back in session. The Honorable Judge David
Maybe Sue.
Yep.
Oh, okay.
Yeah.
Good morning, sir. How are you doing? Raise your hand. Do you solemnly swear the information contained in search warrants and affidavit is true to the best of your knowledge, information, belief? Hello, no, I'll wait. Oh,
You're doing so good.
There's probably a big stamp of the foot there. All right, sure, take care of you. Stay safe. Court does call the case of the people versus Wheaton Mather.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Mathers coming up to the podium.
Wheaton, Eli Mather.
Okay,
Your Honor, we're going to be waiving the preliminary examination today.
all right. Is that correct, sir?
Yes, sir.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand that you will not have that hearing and that you'll proceed to circuit court for further proceeding.
Yes, sir.
People also waive the right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 and 3 following.
Your Honor, ask the court to please waive reading. Mr. Mather continues to not guilty plea. Ask for a pretrial date, and then I just have one request related to bond, if I may.
And then having waived formal reading, standing mute, court will enter a not guilty plea as to all 3 charges. Pretrial in this matter will be set for
August 1st at 1:30 before Judge Conlon.
21st.
Yes.
August 21st, 2024, 1:30, Judge Conlon. As to bond.
Mr. Mather is hoping that the court would allow him to transfer the drug test into Jackson County where he lives. It's very difficult for him to get here. He doesn't have transportation and it's a once a week drug testing. So it'd make life a lot
Has
easier.
he updated his address with the court?
Doesn't feel like it based on the court's reaction. Like
I don't.
directly do that.
Well, I don't know.
What's up? May I address you? Yeah, what's up? You got no interest?
Yeah, we've got it.
He says he's in temporary housing. He says permanent housing is very difficult for him to come by, Your Honor.
So bond will continue. Defendant is approved to test at an approved facility in Jackson. So you'll have to speak with community corrections. All right.
Thank you, Your Honor.
Thank you.
You'll make sure that you have to sign whatever facility it is, they sign a release so that the results get to our.
Yes, sir. Thank you.
Thank you.
Go over there today.
That was mad.
Yeah.
Yeah, but you,
Sorry, I was updating the account, sorry.
her, I did not answer.
I think
Let's do
that's,
that.
okay.
So I'm just having stuff on my own.
I know you guys were hoping I'd run an exam this morning,
So
but
I won't be holding on Antoine Pitts.
No, I was looking forward to hearing from Miss Hughes now. All right.
Oh.
You're more than welcome to stay though, Mr. Gage.
I was ready.
All right. This is going to be a remand down. We'll call them out sometime today. Court does call the case, people versus Antoine Pitts.
Nicole, who's on behalf of us.
good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Pitts. Mr. Pitts, please say your name.
Antoine Pitts, ANTJUAUAN.
Thank you.
Dismiss the felonies. Just continue with the misdemeanors, a slight change.
And at this time, the people are not able to proceed on count 1, count 2, and count 3 of the motion to remand on the misdemeanor domestic violence count 4.
I move to dismiss on the counts the prosecution is unable to proceed on.
All right. Counts 1, 2, and 3 are dismissed. Defendant's not guilty plea will continue as to count 4. Set a pretrial, that's a one case. July 22nd, 2024, 1 p.m. And that's before me for pretrial. All right.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you, Your Honor. Have a great day to your staff.
Thank you.
It was drizzling when I got it. Like a foot. Drizzling.
Court does call the case. People of the State of Michigan versus Matthew Bailey.
Nicole, who's on behalf
Assistant Public Defender Odetell on behalf of Bailey, who was seated, Your Honor.
All right, very good. All right,
Your Honor, today we'll be proceeding to preliminary exam.
all right.
I'm going to ask Deputy Zeal to come into the courtroom and remain in the courtroom as the officer in charge, and then Deputy Croyton will be my witness, and I do not have any other witnesses present in the courtroom.
All right, very good. All right,
People will start by calling Deputy Croyton.
all right. Come forward. Be sworn.
You solemnly swear to affirm the testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
All right, you may inquire.
Thank you, Your Honor. Deputy, where are you currently employed?
Sheriff's Office.
In what capacity? For how long have you been employed as such?
4.5 months.
Were you working in your capacity as a Washington County Sheriff's Deputy on May 25th, 2024? Were you working at approximately 20:45 hours? On that date and time, were you working in the area of 2881 International Drive, Ypsilanti Township, Washington County, Michigan? Was there a specific apartment located at that address that you were dispatched to?
Yes. Apartment 1931 Bravo that we were dispatched to. Initially, it was reported as 1931 Charlie, but we were able to locate that.
Did you have the opportunity to arrive at the appropriate apartment? When you were at the appropriate apartment, did you make contact with anyone? While you were interacting with Miss Leary, did you have the opportunity to observe her demeanor?
Yes, I did.
Your Honor, may I have one moment?
May.
I apologize, Your Honor.
No, it's okay.
Correct.
Okay, I apologize, Your Honor.
Yeah.
As I started taking the deputy's testimony, I realized this was a phone interview with the defendant, not an in-person interview with the defendant. So I don't have an identification witness today. So at this point, I'm not able to proceed further on count 1, and I have to motion to remand on count 2.
Oh,
I apologize, and I apologize to the deputies. I spent most of your time this morning getting you guys stressed and prepped. I should have recognized that.
Mr. DeGiles, you have any objection to that? On what basis? I know Mr. Odetell told you to do that, but now you gotta put the basis, put you up there to say it, but go ahead.
on the basis that the only witness here today would present hearsay. The complaining witness is not here. We don't have evidence to show that my client committed either offense in this case.
But wouldn't that, it's a misdemeanor case, so isn't that something for the trial court to deal with at the misdemeanor level?
If you say so, Your Honor.
I do. All right.
Thank you, Your Honor.
So count one is dismissed. You may step down, sir. Count one is dismissed. The case is remanded to the 14B District Court. Defendant's not guilty plea will continue as to count two. I'll set pretrial in that case for July 22nd, 2024, 9 a.m. before Judge Washington.
And may I address the hunt?
Oh, tell her to say that. I think so. All right. Yes, you may.
Thank you, Your Honor. So with the felony out of the way, we have nearly a misdemeanor case now. My client was previously working at Sweet Green and has been in communication with
Working where?
Sweet Green, I believe on Washington.
Yeah. Okay.
And he plans to go back there, returning to work. He has no objection to a tether if necessary, but I don't believe there's allegations that he's tried to contact a complaining witness in this case. My client is a proud father. He's got 3 kids. There's no parenting time order, but he does see them often and hopes to be even more involved in their lives now that their mother has been unfortunately diagnosed with cancer. So to get back to work, help provide for his family. And again, now that the felony is gone, we just have a misdemeanor with him on a personal bond.
So he has a separate address.
I believe his address is on Aqua Lane with his sister.
Yeah.
Got it. Okay. I see that. Any response from the people?
The defendant has 2 holds, traffic hold from Livonia, traffic hold from Canton. Looks like he has to post $730 cash on those files before he could be released, but neither of those are Washtenaw County cases. In regard to the tether, if the court is to release him, I am requesting a GPS tether for the victim's address on International Drive. As you can see, Your Honor, the victim is not here. I do have concerns, although I don't have evidence to present to the court regarding those concerns, but I do have concerns after my office was in contact with her about the continuation of this relationship.
Here's what I'm going to do. I'll reduce the defendant's bond to a $25,000 personal recognizance bond. All of the previous conditions you understand still are in place. You understand that? You understand that you're to have no contact as a direct or indirect with Miss Leary. You understand that? Are the children that you spoke of, counsel, are those children in common with her?
No, Your Honor.
These are other, okay. So you have no contact with Miss Leary. You are not to go to the address of the 2881 International Drive. All right. You're not to be anywhere around that complex. You understand that? Okay. Thank you. Yeah.
I apologize to the court.
Pardon?
I apologize to the court for my interruption.
When? When did you interrupt me? No, when did you interrupt me?
Say it in general.
In general? You're good. Don't worry about it. It wasn't your fault. It's his. Is that it? Seriously? What? Get out of town. Can we check next door to him?
I'm so sorry I did that, but I started the
Oh, don't even worry about it.
Deputy is mortified that I just did that to him. I'm really sorry, guys.
No, it's okay. Mr. Giles? Approach. Yes, please. Yes. Well, no, we're good. We're good.